and welcome to a very special breaking news live stream. The U.S. Supreme Court has just issued a ruling in the Biden administration's vaccine mandate case. It was a split decision. There were two cases before them. And Rick, I'll let you explain exactly what the ruling is.
Yeah, thank you, Catherine. I just got finished reading the ruling on the OSHA vax mandate case. And that case was the OSHA, which is part of the Department of Labor, had issued a regulation, as most people know. The regulation was would have required employers who had more than 100 employees to fire anybody who was not vaccinated. It was, or they would have to wear, in some instances, could wear a mask and be tested on a weekly basis and still retain their job at the employer's discretion. And so what we had was it was an overreach by the Biden administration to try to get OSHA, Occupational Safety Hazard Administration, to go ahead and do their dirty work by forcing people to get vaccinated or lose their livelihood. The Supreme Court said that is going to be that will be stayed, which means it cannot be enforced by the Biden administration, and effectively the regulation is wiped off the books unless the Biden administration appeals on constitutional grounds that it should be accepted, and then they could go back in and re-argue and have another fight over it. The opinion is pretty clear, though, that 6-3 basis that the vax mandate far exceeds OSHA's authority. It says very clearly that Congress did not authorize this, that this is an administrative action without a congressional grant of authority, and that it's unprecedented in its breadth. And as a result, the court, I do not know how the court would rule if Congress said they wanted to do this and authorized it, because one of the kind of legs of their argument was that it did not have congressional authorization, and they didn't deal with the essence of the question is whether the federal government has the power to do this. And this gets you, and so it's a great decision. It's 6-3. Very highly unlikely that the Biden administration will even appeal. And the reason they won't want to appeal is because this is a stay. This is a temporary thing. But if they appeal and there's actually a decision on this that is more of a formalized decision rather than a stopping of an administrative action from going forward, it has the decision, the rationale has a lot more long-term consequence. And so they likely will not push their luck and proceed to beyond appealing the stay and saying, hey, we still need this done. We want the court to decide whether this is constitutional. So understand, it's a stay against them, against the implementation. The OSHA mandate, in my estimation, is probably dead. I think it's 99.9% certain it's dead. That is great news, and it's phenomenal news. This affected millions upon millions of people, and really but the guts of why limited government is so important, because when the federal government can reach down into your job and tell your employer they have to fire you because you're not doing something the federal government wants, that's fundamentally wrong. It's evil. It's counter to the entire concept of American justice. It's counter to our constitutional principles. And so I'm glad the Supreme Court came down the way they did. Although I would have liked the case to have been decided by more of a limitation on federal government authority rather than on the narrow grounds that Congress hadn't authorized it. So there's a second. So let's talk. Catherine brought up a second case, and the second case was this administrative action had been stopped, and now this stay has been lifted, and so it's a loss. And the administrative action was out of the Health and Human Services Department. And they had issued an edict to hospital systems and healthcare systems that they had to fire anybody who was not healthcare workers who did not have a vaccine. And that was and the Supreme Court lifted that prohibition that had been put in by a lower court on it, allowing and basically giving the HHS that power over over those healthcare systems. And this one's really kind of, it gives tells you why I wanted it to be a constitutional decision based on constitutional basis as opposed to the narrow congressional authorization rationale. Because under this decision, because a healthcare system takes Medicare or Medicaid, they are subject to federal regulation as to who can work in those facilities. I have not read that decision. I read the other, the OSHA mandate decision, because it affects far more people. But the fact of the matter is, this split decision leads to the very heart of the question about what the federal government's power is. It's the battle we fight every day in Americans for Limited Government. And quite honestly, it's why the Congress now needs to go back and readdress Obamacare, readdress the power of the federal government over our healthcare system, and as was once promised by Senator Mitch McConnell, rip it out root and branch. Because the way to deal with this is to for Congress to clarify by making it clear that this is not federal government authority. The power of purse strings does not extend to firing healthcare workers. And unless Congress takes that action, healthcare workers are going to be fired at a time when we cannot afford to have healthcare workers fired. That is the absurdity here, and it's a breach of the contract between the federal government and the localities. But that's the decision, as best as I can tell, reading the top lines on it. And it's a dangerous decision, so Congress needs to act in that regard.
Rick, Mason asks a really good question. Does this mean that those individuals who lost their jobs over this mandate have the right to sue? I think that's a little complicated, right? Because there were private employers who were putting in mandates separate from what the federal government was doing. So like if I worked for United Airlines and they fired me because they had just their own internal policy, that's different from the government.
Yeah, that gets really tricky. And you're right. Recognize, Mason, neither, we can read the law and we can read the decisions and we can speculate. Neither Catherine nor I are attorneys. And while I sometimes play one on TV, I'm not going to play one here. However, I do believe that as Catherine stated, a private employer's relationship with their employee is that relationship, unless there's a contractual, and most employees are at-will employees. And so if the employer decides, I don't want you working here anymore, they don't really have to give a reason. But I do believe what it does is it eliminates the ability to deny unemployment claims based on this. And what's more, if an employer said to that employee, I really want to keep you, but the federal government is forcing me to fire you. And if they were to do that, then that would be, at that juncture, there might be grounds for a federal suit. Although it would be very costly and difficult and take years and years and years to get to the point where a federal government regulation that caused people to lose their job, that was found to be unconstitutional, or was stopped by the federal government, by the Supreme Court, that there would be financial repercussions against the federal government because of the ill effects of their regulations. Right. That would be pretty unprecedented. And let me explain it to you this way. We have regulations that deal with all sorts of things on environmental stuff. And I'll just give you some basics. Let's say there's a regulation on clean air, and the air wasn't clean, and cities were fined because the air wasn't clean, and corporate and different people were fined because the air wasn't clean, as based on the Clean Air Act. So somebody gets sick under that circumstance. That person doesn't have the ability to sue the federal government for failure to enforce, or a state government or local government, or even their employers under those circumstances. So similarly, if you got fired because the federal government had a regulation that got found to be unconstitutional, I think you'd have a really, really, really difficult pathway in court. Once again, I am not an attorney. I didn't stay at a Holiday Inn. I haven't done any of those things, but I do think it's the precedent of allowing for lawsuits on that basis are difficult. The only place where that would be different is if the federal government made a rule that took away your land, took away your business, at which point you would have a takings clause, a Fifth Amendment case. And it's a fight. I believe that the takings clause, there's taking clauses cases should have been done a long time ago on Endangered Species Act rulings and the like, which take away the value of their property. And I believe it's a legitimate takings case. And to date, I'm unaware of any takings case along those lines that's been successful.
And Rick, Mason follows up with a very simple question. So was it deemed unconstitutional? And Rick, before you answer, I want to read from the Wall Street Journal. This is how they put it. The court's conservative majority, in an unsigned opinion, said the Biden administration likely did not have the unilateral power to impose a mandate that employers ensured their workers were vaccinated or tested every week for COVID. Okay, so the key word there is the Biden administration likely did not have the unilateral power. So it's my understanding that today's decision does not answer that question. Is it constitutional? It simply says it's likely not constitutional, but we're going to let the lower courts figure that out. And until they do,
actually, I don't think it goes to the lower courts. Here's what happened. They put a stay in place against the implementation of this regulation. They said that they did so because the plaintiffs, the people who were suing the federal government over the regulation on its constitutionality, were likely to prevail in that lawsuit in front of the Supreme Court. But it is not a constitutional ruling from that perspective, because it was merely they stopped the regulation from being implemented, but they didn't say it's unconstitutional. They say if a case came to us on this, we would likely find that it was unconstitutional, and hence they won't allow something that they believe will be found to be unconstitutional to be implemented into law in the time and impact people in a negative way. That's what the stay means, and that's what they say pretty clearly in the decision. And so no, Mason, the answer is no. It wasn't found to be unconstitutional. What they said is it's likely to be found unconstitutional. And that's why the Biden administration will not appeal it, because they do not want it to be found to be unconstitutional, because that has a different weight in terms of long-term stare decisis at the court deciding future decisions. It has a different weight than an order which is a stay, which only says this is likely what we would do.
Okay. And so Rick,
Catherine?
Yeah, what about the healthcare mandate? Let me just tell you what happened there. So first of all, going back to the private employer mandate, the three liberal justices, Justice Breyer, Justice Sotomayor, and Justice Kagan, they dissented. So they disagreed with the other, how many do we have? 9 justices? They disagreed with the other 6 justices. And they said, yeah, this is fine. We're fine with OSHA putting this on. And I think a lot of us expected those 3. But now we look at the ruling in the healthcare mandate. And you have, again, Justice Breyer, Sotomayor, and Kagan all saying, hey, it's fine. But you also had Justice Kavanaugh and Chief Justice Roberts join the liberal wing in agreeing that this mandate is fine on the healthcare workers. What do you think was the difference there, Rick?
Well, first of all, once again, what they're saying is that the argument on healthcare was likely to prevail. And I think the difference is that HHS has a financial relationship with the agencies that take Medicare and Medicaid. And so healthcare agencies that have Medicare and Medicaid are effectively contractors to provide health services to seniors or the indigent. And and so that financial tie, whereas OSHA has absolutely no power whatsoever to regulate individual behavior. Their power is over the workplace and not individual behavior. And so that's OSHA's limited power. Health and Human Services has a different relationship, and they essentially, Catherine, as I said up front, I have not read that decision yet, but what I am projecting is that the decision was all about the financial relationship between Health and Human Services through Medicare and Medicaid to those hospital systems and the like, and that the decision was essentially that because of that financial relationship, and because it didn't extend beyond that financial relationship to healthcare providers who don't take Medicare patients, for instance.
Rick, I think that kind of also underscores the point of our organization, Americans for Limited Government. Anytime a private entity takes federal dollars, there are always strings attached, and it comes with contractual agreements and duties and responsibilities. And this appears to be the case. If you're a private hospital and you take federal Medicare or Medicaid dollars, which I think virtually all hospitals do, you are then under further restrictions. Should the federal government come in and say, whatever restriction of the day they want to put in, they have more control.
100% correct. And I think this, and once again, stretching beyond a little bit beyond what I know, I do know that there have been some separate cases related to whether or not federal contractors should be subject to an OSHA-like mandate because they are contractors, defense contractors, heck, Staples, if they sell a bunch of paper to the government. Anybody's a federal contractor, are they subject to these kind of requirements? And I think I'm not confident that ending the OSHA mandate affects those contractors the same way it would affect a factory that doesn't produce something that the federal government's immediate contractor for. And as a result, we may be in a situation where if you are a big company or even a small company that is a federal contractor, you may end up subject to one set of rules because of that financial relationship. While if you're not a federal contractor, you're subject to a different set of rules. It would not surprise me if that's the case. That specific issue likely was not addressed. But if HHS, if providing Medicare services puts you at risk of having HHS tell you who you have to fire, then you darn well better believe that if you're a contractor selling a lot of widgets to the federal government, that same direct financial tie would exist and could be extrapolated to mean that the same kind of mandate could apply to federal contractors. Once again, I'm getting a little bit ahead of my skis on this because I haven't looked at it at that closely, but that logically follows, and so be very careful if you are involved in a federal contractor. The ruling on the OSHA mandate may or may not apply to you because you have a different relationship with the federal government.
And Manda Lee asks a good question. What about state employees? I don't believe that either of the rulings today, neither of those cases involved state employees, but right. I'll let you answer that, Rick.
OSHA only affects private employees. It does not affect any public employees because the Labor Department only has jurisdiction over the private employment workforce. And so it doesn't have any impact on public employees. State employees would be a decision based on state government. And and I feel badly for those people who work for states like California and New York, as they're subject to mandates from administrations that, quite honestly, I don't think have their own people's interests at heart. But neither of these decisions would have anything to do with state employees or local employees, local public employees either.
And Rick, Robert, our policy vice president, weighs in. He says federal employees and contractors was the executive order. So that was handled outside of OSHA. It was not part of today's ruling.
Right, exactly right. And that was an executive order. But once again, the reason I brought it up is because there is not this isn't a get out of jail free card for people who are federal contractors. They are still subject to this law because the Supreme Court didn't deal with it. They dealt with the relationship between the federal government and private employers. That's right. What they dealt with. And obviously, if you're a federal contractor, you have a different fiduciary relationship with the federal government, and that executive. And has not been a case taken to the Supreme Court that actually deals with that question, whether that executive order is valid or not.
And so, Rick,
let me finish. The executive branch is, by design, in control of the administration of policy, and so this is a case where a federal contractor, as an agent of the Article 2 branch of government, the president, the executive branch, they are in fact an arm of the Article 2 branch and subject to control of the Article 2 branch based upon the contractor relationship. And so it's really hard to get to a place where you can see the Supreme Court saying that the executive branch can't impose conditions on federal contractors. And so it's I know there's some legal arguments on it, but given what we know on the HHS decision, it's hard to see them getting to a point where they're going to take down the Biden executive order on it.
So, Rick, to me, this whole it's a mess. Like, it's so complicated. You have Department of Defense making mandates. You have the federal government making mandates on its employees and its contractors. Then you have OSHA putting mandates or attempting to put mandates on private sector employers. And then you had the Department of Health and Human Services trying to impose mandates on healthcare workers. And it really underscores what the justices were asking in the oral arguments. Is one of them asked, this seems to be a workaround, what the Biden administration is doing, these different mandates and using different agencies. And the justice asked, what are you trying to work around? And I think that, to me, that's one of the core issues here, is the Biden administration, they would like to have had, I believe, Rick, they would like to have had the ability to just mandate that every U.S. citizen get vaccinated. But I mean, I think that was so clearly unconstitutional that they attempted to use these other levers and means to get as many people as they could. Is that an accurate reading?
I think it's completely accurate reading. And the number of employees of the OSHA mandate, 100 employees, was an arbitrary number. If you're in a small room working with 10 people, are you any less susceptible than if you're in a large room working with 101 people?
Exactly.
Okay? So it was an arbitrary number they picked. And I think while that wasn't addressed in the decision, I think it's pretty clear that the objective was to compel the most number of people to impose to succumb to the vaccination, and to use actually the threat of a fine against an employer, and basically turn the employer into the enforcement agency for the federal government. That's what they were attempting to do, and they're essentially pitting their employer against the worker, and the employer was suddenly going to be the one who ends up being the bad guy in terms of this. Like the Nuremberg trials, saying, well, I'm just following the law, and but I'm just following orders. But that's essentially the difference. They knew that smaller employers wouldn't have the resources to do it. They don't have HR departments and the like to enforce this kind of stuff. And so they made an undue burden decision about the ability to enforce. But the bottom line is it was arbitrary in picking the number 100, had no health value whatsoever. And as a result, they did talk about the arbitrariness in the decision, in the stay order, of different companies having different circumstances, different type of employment having different circumstances, whether you worked in the landscaping industry or not, having different circumstances. And so they talked about the differences in the workplace between that are manifestly clear between one workplace and another. And that was part of the rationale as the Supreme Court wound its way to their finding on the OSHA mandate. And ironically, the federal workers, the federal contractors, you could be a company with 10 people in it, and be a small business under 8A, a minority-owned small business, and be a federal contractor and have 10 employees and be subject to this. Whereas if you were not a federal contractor, you wouldn't have been subjected to the OSHA mandate at all. So it's really going to be confusing for a lot of people on this. But ultimately, the question is, people are federal contractors. They know it. And right now, federal contractors are still subject to the executive order that Biden put out affecting their employment and the imposition of vaccine mandate.
Rick, you mentioned something just now that I really clued in on. You said some of the mandate language was arbitrary in terms of how it was applied and to whom and what size of company. Was that a key factor, do you think, in the court's decision? Were they looking at the arbitrariness of these mandates and how they were worded?
They didn't mention that in the decision in terms of the 100 employees, but they did mention the diversity of workplaces that were impacted and how the different workplaces have different circumstances, and that there was little flexibility in terms of those circumstances. So they were more concerned about the fact that there's a one-size-fits-all solution than whether or not the arbitrariness of picking a number.
Gotcha.
And that's a great question. They didn't. That's when you get down to it, I didn't even know if that was argued before the court, the arbitrariness. But fact of the matter is, they did focus in like a laser beam on the different employer-employee situations, and how a one-size-fits-all solution is not efficacious and doesn't make any sense.
So then we have a comment. Why wasn't the fact that these vaccines are not preventing spreading the virus in the court hearing from either side? Actually, Rick, I don't know if you want to address that, or I want to just say a point to that. And I'm starting to hear some of this, other people making commentary, and in my own personal experience, millions of Americans have either gotten this Omicron variant or they think they have it, and there's not enough test kits out there for people to confirm. But if we look at what happened in South Africa with the Omicron, the cases went up very quickly, and then they have dropped equally as fast. I mean, that could be the case that by, the next 4 to 6 weeks, we may have run the course on Omicron, and these vaccines really weren't effective. And I mean, are we getting?
Let me give you the answer to the question, and what you say is 100% correct. Well, breakthrough cases are now the norm. They're not an anomaly. This is one of the things that happened is on the healthcare side of it. The American Medical Association issued an amicus brief very clearly saying that they believed they were in favor of the vaccine mandate. Okay. Unfortunately, the facts related to the vaccine efficacy weren't included in any of the amicus briefs. And and once again, one of the limitations Americans for Limited Government has is I don't have a general counsel, because we would have put that in as part of one of the things we would have mentioned in an amicus brief with a lot of information related to it. But without a general counsel, I don't have the capacity to do that. I don't have the funds to go off and pay somebody to do that. But unfortunately, those who were fighting this didn't want to fight the vaccine mandate battle as it related to the efficacy of vaccines. They didn't want to fight the battle in terms of whether or not this was even good health policy. because they thought that I'll just guess, but I think they thought that muddied the water as it related to the legal issue of whether or not the federal government had this power and whether the OSHA statute in particular granted this power. And so rather than get into that issue, I think they chose a different path. But yes, you are 100% correct. A lot of the assumptions, the proponents of the vaccine mandate, the proponents of the OSHA mandate, directly were making claims about the effectiveness of the vaccines that was completely false. There was no recognition of the adverse impacts of the vaccines. There was no recognition of choices the government made related to treatment and efficacy of treatment. There were none of those kind of discussions in this court case, and hence the Supreme Court only rules on what's in front of them.
Right.
And so I will just say, our side on this, the reason they didn't talk about it is because our side failed to bring it up. And that is a failing that we cannot allow to occur in the future.
Hey, folks, if you like what you're hearing and you want to be a part of our community here at Americans for Limited Government, subscribe to our channel on YouTube, Rumble, follow us on Facebook, and on YouTube, make sure that you hit that little bell. That'll ensure that you get notifications every time we go live. And Rick, the last thing I want to say is this guy here on YouTube says, plus the CDC mentions a negative test does not mean you're not infected. I'm confused. So this is a little off topic. As Rick said, the rulings today did not address the efficacy of the vaccines. But I just want to say, and I think a lot of us are feeling this way, that the CDC has just gone off the rails with its messaging. I don't know from day to day what is going on over there. And then add in, you have Supreme Court justices, misinformation super spreaders during last week's oral arguments. That just is indicative to me that so many Americans are getting bad information. I don't know what news sources those justices were watching, but there's just a lot of bad information out there. Some of it is coming from the CDC. If it's not bad, it's certainly confusing to a lot of us. I can barely keep up day to day what the newest mandate or recommendation is for how many days you quarantine or when I'm going to be able to get a test kit. When do I need a test kit? I mean, I think this is a nightmare.
It's dizzying, the changes and everyday seeing changes and what the rules are. The specific answer to your question is the instant tests. When you get a negative on an instant test, they also give you a second test at the same time. At least they've done that with me. And you aren't actually you're temporarily cleared of having the disease until your more precise test is evaluated, which takes 3-4 days. At which point you get a final okay. The instant test, if you have an instant test and it's found to be negative, you proceed as if you're negative until the longer test gives you some other indication. But it's really confusing. And the fact of the matter is, the most danger, if you think about it, since most of the treatments like monoclonal antibody therapy and the like, it's 5 days. You need to get the treatment within 5 days of having symptoms. And if you get a false negative, which is possible, you also get false positives, you actually have a good chance of missing the window for getting the effective treatment for the disease. And that's the danger point of a false negative. But yeah, it's confusing as heck. And we all wish that we didn't have Dr. Fauci up saying something different every single day, the head of CDC saying something else different every single day, the FDA coming up with their own spin on whatever's going on, and then the White House having their spin on what's going on. And if we spend a lot of time following this, and if we get confused, I hesitate to think what people are just trying to, just want to follow the rules.
Yeah.
They seem to have the rules change all the time. You have to mask, you don't have to mask, you've got to do this, you got to do that. Ultimately, it's the rule of law. Laws work when they're clear, they're concise, and they're understandable. And
when they're based in fact.
Every one of those rules repeatedly, And it's no wonder that the American public looks at the CDC and say, you don't know what you're talking about, and I'm not going to follow what you're saying, because when you keep shifting, when your stance is just shifting sand, nobody's going to, how are you going to know what the heck the truth is?
Well, Rick, that's why people like you and I and our organization in general have been saying literally from probably day one, make your individual choices based on your own risk assessment, but do what's right for you. Like each person has a different risk tolerance or different underlying conditions or concerns. But from the beginning, I think this should have been just like we handle most every other sort of risk in our lives. We make those determinations for ourselves. But instead, the federal government came in and really, I think this has just been terribly mishandled.
Yeah, and recognize while President Trump was instrumental in the development of and getting the FDA kind of roadblocks out of the way, the development of the vaccines, the Trump administration specifically avoided doing anything like an OSHA mandate, doing anything like demands on employers to follow certain procedures. That came into being when the Biden administration came into play, and they felt like they had to do something besides what the Trump administration was doing. And so what they did is they said, we're going to force you to get vaccinated, whether you want to or not. They said, we're not going to allow for natural immunity to be a reason not to get vaccinated. We're not going to recognize that. And we're going to throw out the window the whole concept of herd immunity, which Dr. Fauci was talking about from the very beginning, that there was something called herd immunity, and which apparently Dr. Fauci no longer believes exists. So so the fact of the matter is, and I think Roger Marshall, senator from Kentucky, I think he's the one who said this, his doctor, and talking to Fauci at a hearing a couple of days ago, he specifically said, if you were the manager of a baseball team, or if you lost all credibility, where nobody believed anything you said, and you would get off the field, you'd stop being on TV because you're doing more harm than good. Why haven't you left the field? And Fauci, and basically taking on Fauci directly on his lack of credibility, because he's been all over the map on everything and is quite possibly probably culpable in the development of the virus, at least at the beginning stages, based on the funding of the Wuhan lab. So so he has absolutely no credibility left. He needs to be shuttled off to the sidelines. And quite honestly, people on the left have been recommending to Biden that he shuttle him off to the sidelines, because he's muddling the message, and he's actually doing harm to Joe Biden's ability to lead in this crisis. So that is exactly, so yeah, you're right. CDC, Fauci, the whole lot of them need to take a step back, stop saying stuff, and allow the people to kind of catch their breath, figure out what's going on, and make their own decisions based upon their own circumstances and their own vulnerabilities. And, like in all those circumstances, we also bear the consequences of those decisions.
Right.
But as free Americans, we have a right to bear the consequences of those decisions.
Right. Absolutely. Thank you all for being a part of our conversation today. We're very grateful that you clicked on that email, and make sure that you subscribe to our YouTube channel, hit the bell so that you get notifications of when we post videos and go live, and also subscribe to our newsletter. You can do that at dailytorch.com. And we just want to say thank you for being a part of this fight. And Rick, do you have any last words?
No, I do want to thank each and every one of you. This is, while it's somewhat of a split decision, it is actually, the OSHA thing was huge because it was such a dramatic expansion of government power. And today, the 6-3 majority in the Senate found that that expansion of federal power was unacceptable. And and I think we can guess that if Hillary Clinton had been picking the judges the last 4 years at the Supreme Court, the OSHA mandate would have been upheld, and it would have been disastrous for freedom in America. So, for all the struggles that have existed in terms of getting court judges put in place, and some of the disappointments that have occurred with some of the rulings they've made, today I feel confident that that fight was worthwhile, because if OSHA had been allowed to have this power, if the administrative state had this power over having our employers fire us based upon our healthcare status, it would have been Katie bar the door in terms of any kind of ability for us to operate in a free America. And so today validated that, and just thank goodness that we were able to successfully get the Supreme Court to have a 6-3 majority. I'm not going to, listen, Kavanaugh and Roberts joining with the left in their healthcare decision, disappointing. But the fact of the matter is, if we lost the OSHA decision, it'd be really hard to go back and say we need a Senate, we need a president because of the Supreme Court, because we would have lost a great deal of our freedom on that. And so thank goodness that we got that decision. It would have been disastrous if it hadn't come through.
All right. Thank you, Rick. And we'll see you next time on an Americans for Limited Government live stream.
Thank you, folks.